for joining. I really appreciate you all being here. Today we're going to be talking about municipal court and pro bono attorney training because a number of you, perhaps who are watching right now, have volunteered your time with the representation of protesters in municipal court. And so we wanted to provide this training to you, to law students who are interested in this topic, as this is crucial to have this type of legal support in a time where social movements are imperative in fighting to uphold and further racial justice, challenge systemic and institutional racism, and stop the violation of civil rights and civil liberties. So we all really appreciate your time and your being here and your dedication to these issues. And so this is a 3-part training, as you can see here, which will be held for 1 hour from 12 to 1, today, of course, Wednesday and Friday. And today, Judge Jim Gramling and I will be discussing protest rights, protest-related citations, and an introductory overview of the municipal court. And then on Wednesday, we're going to have attorney and soon-to-be Judge Corey Ashley and Judge Jim Gramling talk about municipal court pretrial and trial procedures. And then on Friday, we're going to have attorney Susan Lund and again, Corey Ashley will be discussing post-judgment matters in municipal court. And so you're really going to get, hopefully, a great idea of how to navigate municipal courts and how to deal with especially curfew violations and protest-related tickets in municipal court. You should have access to a Google Drive link where we have an outline of this training that you can follow along with as well. And so we also included additional materials for each part of this training. And they include things like templates, guidebooks, and bench books that we'll also reference in the outline. But for the purposes of today, feel free to just follow along in our outline where we also included links to a lot of these documents. And please let us know in the chat if for some reason you can't get access to that link and those folders. The outline document is just in the general folder, and then there's folders within them for each part of the training. So first, before we kind of get into it today and talk about the municipal court overview, I want to introduce myself and I want to introduce Judge Jim Gramling if you don't know us already. My name is Emma Shakeshaft and I'm an Equal Justice Works Fellow at the ACLU of Wisconsin. I'm sponsored by Quarles and Brady and the John M. Kohler Foundation. And I focus on a specific project related to debtors' prisons. As an attorney in the legal department, I also focus on criminal justice, criminalization of poverty, and racial justice issues, which I think align very well with the issues that we're seeing today, and especially protest-related tickets, and curfew violations. And so my specific project challenges modern-day debtors' prisons in Wisconsin by urging courts to pursue more rational and equitable approaches to criminal justice debt. And that's something we're going to be talking about throughout these trainings. Before joining the ACLU of Wisconsin, I was a Law and Society postdoctoral fellow at Tulane University, and before that, I was at the American Bar Foundation in Chicago. I went to law school at the University of Wisconsin Law School, and I completed my doctorate and my master's in sociology at the University of Wisconsin-Madison as well. So I'm really dedicated to these particular issues, and I also have a passion for research and kind of knowing more about municipal court processes across the state. I'd also like to introduce Judge Jim Gramling, who graduated from the University of Wisconsin Law School in 1971. He then worked at Legal Aid and Defender Society of Greater Kansas City, Missouri until 1977, and was at Legal Action of Wisconsin until 1986. Judge Gramling then successfully ran for the position of municipal court judge in Milwaukee and was reelected a number of times until retiring in 2007. Since that time, he's worked as a volunteer attorney at the Center of Driver's License Recovery and Employability in Milwaukee. He's a member and past president of the Wisconsin Access to Justice Commission and a board member of the Wisconsin Justice Initiative. So needless to say, Judge Gramling has dedicated his career to public interest law and public interest service, and I'm consistently and constantly grateful to be learning from him. So you'll hear from him in talking about the municipal court overview today.
Thanks, Emma. Delighted to be part of this training. Thank you.
Of course. So I just want to start by talking a little bit about know your rights. And this is not necessarily for all of you if you are already practicing or are a law student, but I do want to give you these resources to pass along to your clients, because we do a lot of Know Your Rights training, and I think it's important that your clients know about this because they might be participating in protests in the future, and could be dealing with a lot of these issues again. So I wanted to just throw out a couple of these resources. So we're going to be doing Know Your Rights. We're going to do unconstitutional protest activity. I'm going to discuss a little bit about what the ACLU focuses on, and not that that's going to be part of your case, but I do want to flag it because there might be some overlapping issues. And then we're going to talk about and have a discussion and update on protest-related citations that might have a large impact on your actual case, and then doing an introduction to municipal court. And then our future trainings, which I'll talk about at the very end. Part 2 is going to really get into procedural and substantive law with pretrial matters and trial practice, and Part 3, post-judgment matters in municipal court. So just flag those for Wednesday and Friday as well. So in your handout, in that outline, you should be able to see some resources. There's a Protest Know Your Rights material, that's a pamphlet, as well as Navigating Municipal Courts pamphlet and video. And this might, this is for your clients to help them navigate in case they ever are kind of forced to go to municipal court and don't have legal resources or are not being represented. So feel free to pass that along to them. But just a couple of things about your rights, your client's rights, and protest. So important things to just note, where can you protest? Really, you're most protected in traditional public forums, plazas in front of government buildings, as long as you're not blocking access to the government building or interfering with other purposes of the property that it was designed for. You do have a right to photograph anything in plain view, including federal buildings and the police. No permit is necessary as long as marchers don't obstruct car or pedestrian traffic. And those boundaries and those lines are often something that we pay attention to. But a lot of these rights are restricted. So private property owners can set rules for speech on their property. The government may not restrict your speech if it's taking place on your own personal property or with the consent of the property owner. On private property, the owner may set rules related to photography or video. And if you don't have a permit, police officers can ask you to move to the side of the street or sidewalk to let other people pass by for safety reasons. So those are all the things that, that we want to share and think about when going out to protest. And for those of you who might not have the handout yet, it's in the Google Doc in the folder. And so you will continuously send out that link just in case you logged on late. You probably wouldn't be able to see the link. So we'll do that a couple times throughout the session today. So what happens if there's a police issue and the police issue an order to disperse the protest? Police may not break up a gathering unless there's a clear or present danger of a riot, disorder, interference with traffic, or other immediate threat to public safety. If they do, so this is supposed to be narrow, a narrow situation in which they do this. If officers issue a dispersal order, they must provide a reasonable opportunity to comply, including sufficient time and a clear unobstructed path to disperse. And that's also something that we see a lot, and affiliates across the country have brought litigation on this particular issue. Everybody who is there must receive clear and detailed notice of a dispersal order, including how much time they've had to disperse, the consequences of failing to disperse, and what clear exit route they can follow before they may be arrested or charged with a crime. And so I'm going to mention this a little bit later too when we talk about unconstitutional issues that are flagged. So I'll come back to that. What do you do if the police ask for your phone or show up at your house? And this is a particularly important issue for those of you who are representing protesters in municipal court, because we have heard that law enforcement and FBI have been showing up at individuals' homes after they were ticketed, after the protest was over. And so this is something you really want to pay attention to and ask your client about, if you haven't already, to say, have you had this police contact? Police officers may not confiscate or demand to view your photographs or video without a warrant, nor may they delete data under any circumstances. However, they may order citizens to cease activities that are truly interfering with legitimate law enforcement operations, and what that means, is always part of the argument. And inform your client not to speak to law enforcement without you present. That's incredibly important given, again, the instances that we've been hearing about where FBI and law enforcement are showing up to protesters' homes days after the event. And also inform your client that they should not give law enforcement permission to search their person or property. And so again, tell your clients not to give your phone, not to discuss the case, and especially if they are represented and have been ticketed. So that's just something to note based on things that we've been hearing. So what do you do if your client believes their rights have been violated? Of course, they have you to represent them in a certain capacity, but tell your client to write down everything they remember, including the officer's badge and patrol car numbers and the agency they work for. Get contact information for any witnesses that might be there. Take photographs of any injuries that they might have sustained. And once your client has all of this information, they can file a written complaint with the agency's Internal Affairs Division or Civilian Complaint Board. And so this is something you should see in the handout version of this. You should see a link. We've created a document that kind of talk somebody through the procedures of filing a complaint. And it is different in each jurisdiction. So it does depend on which police department had the violation and violated that individual's rights. So, so the link is there, so you can also pass that along to your clients as well. So another thing, so I said we were going to kind of come back to this unconstitutional activity related to protests that the ACLU pays quite a bit of attention to. Again, this is something for everybody to note who might be representing clients in municipal court, but it doesn't mean you're going to be necessarily litigating these issues. It means, though, that you should kind of pay attention to them, and if you do have a client that's interested in civil litigation, these are kind of the issues that often come up for us. So the first one is dispersing protesters, like we were talking about before. First, these are First Amendment claims often, or Fourth Amendment claims. First Amendment because the act of dispersing might limit free speech by the dispersal, again, if it's not that kind of narrow reasoning for dispersing. Fourth Amendment claims focusing on the way that people are dispersed. It could, and a lot of these overlap, so they're not just kind of one or the other, they're not mutually exclusive, but really kind of focusing on the manner in which the dispersal happened. There's mass arrests and kettling. That's also something that we have litigation related to at the ACLU broadly. And that this means kind of strategically blocking off or kind of being caught in one area. Because law enforcement blocked off parts of an intersection to make sure that people are kind of confined to one space, and then making mass arrests as a result. So this, and this has the occurrence very often of people just being caught at the wrong time in the wrong place. They may or may not have had anything to do with protest activity. They might have not even been at the protest. They might be trying to get home or something like that. And so, this becomes really problematic when there's no, again, outlet for the dispersal. And then, of course, without probable cause of any kind of criminal activity for, a mass amount of people is also, of course, an issue that we pay attention to. Excessive force, of course, is always something that, especially now, we all need to pay attention to and focus on. And so physical violence, handcuffing, pepper spray also comes under the umbrella of excessive force. And video, as we've seen, is often a large part of these cases. And so this is, again, something that we think about quite a bit. Detention and conditions is also something that we look at and see a lot in protests, holding protesters for lengthy amounts of time without food and water. COVID-19 concerns. I mean, this has come up quite a bit recently. Putting people in jail where they might be in danger, of contracted COVID, especially if they're vulnerable to certain conditions, and you know, are more likely to contract COVID and have really serious effects from it. So this is something that we also pay a lot of attention to right now, is how are people being held? Are they being held together? Are they social distancing? These are all really important issues, very often Fourth Amendment and Fifth Amendment concerns and violations. Curfew tickets and enforcement. This is something we're going to talk quite a bit about going forward, but this is something that, again, affiliates have really focused on, and we've done some advocacy around as well. But it's important to pay attention to the broad time, place, and manner restrictions of curfew tickets, the vagueness of the terms of curfew. You know, how long is it? Where are the bounds of the geographical boundaries of this curfew? The overbreadth of the ticket, the freedom of movement or lack of freedom of movement, and what severe kind of negative impacts does this have on that community? So if transportation isn't happening, can people get to their work? You know, what does this actual ticket look like? And there's been litigation across the country on this as well. So I just wanted to flag these again, not because you're going to be litigating them, but if you know the issues at hand relate to this, you might want to either refer your client to, and they want to bring a civil rights, you know, litigation case or a constitutional violation, you might want to refer them to an attorney. And we've offered to do some legal research in those cases. If you're wondering about a specific context with your client, you know, we're more than happy to help you with that legal research and you know, try to come up with some answers. So the last thing I want to do is just give a quick update on what we know about municipal protest-related citations, especially curfew tickets. I included in your handout a link to the letter, the advocacy letter that the ACLU wrote, as well as many of you, perhaps, attorneys that have volunteered to represent protesters on their municipal court violations, community court violations. And so the result of this advocacy has been that we've been assured that a lot of these tickets will be dismissed. I believe it was 191 tickets were issued in Milwaukee, and this is only about the city of Milwaukee, not Madison, which is why we still want to keep curfew tickets here and have that conversation. But 191, as far as we know, tickets have been issued, and 182 of them will be dismissed. So if you have not received notification yet of a ticket for your client that has been dismissed, you know, you should be receiving that soon. And if you don't, we would love to hear from you. But other tickets, you know, very often tickets don't come with just the curfew violation. We've seen other tickets as well, disorderly conduct, resisting or obstructing a peace officer, obstructing, generally like blocking a roadway, perhaps, have been some others. So, you know, there might be other muni-court tickets that we'll need to address if you're representing, you know, if you're representing a client. So even if curfew's gone, you know, we don't know about these other tickets. So something to keep in mind. But one of the issues that I'm particularly concerned about as I focus on debtors' prisons is looking at the cost of these tickets. Curfew tickets are $691. If you have another ticket, you know, as you know, in addition to that, I mean, we're talking over $1,000 easily, very, very quickly. And so for people who are unable to pay these tickets, this can have really dire consequences. And we'll talk about that going forward. I believe in part 3, we're going to be talking about indigency petitions and how to do them. But, you know, it's really an issue that we should all be thinking about up front on these cases, because if someone can't afford it, their driver's license may be revoked. You know, in the jurisdictions where it applies, you know, there might be a warrant that's issued if they don't go to court. You know, luckily they have representation from you all, but in the cases where they might not, you know, there's severe consequences if you're not able to pay and you know, cannot address it with the court or don't know you should address it with the court. So I wanted to flag those issues right off the bat so that we can continue in talking about that in the next 2 parts of the session. So now I'm going to turn it over to Judge Gramling, who's going to be talking and giving a brief overview about municipal courts generally.
Hi again, everybody. Parts of what I have to say are likely to be more interesting than others, but I hope that you'll find it all informative to some extent. What I think can fairly be called the modern era of municipal courts began about 50 years ago. These courts, of course, are the successor to the Justice of Peace courts, which existed in our country's history for many decades and centuries. In Wisconsin, these courts do not spring into life on their own. A governing body in a town, city, or village has to affirmatively decide to have a municipal court. And in our state, there are about 240 municipal judges, municipal courts. That's about the same number of judges that there are in the circuit courts of the state. And 68 of those courts are joint courts. That is, one or more, or two or more municipalities have decided to band together with one judge to have a court that covers multiple jurisdictions. They found it to be more economical than each setting up their own court, especially since some of them have very limited caseloads. In Milwaukee County, each of the 19 municipalities in Milwaukee County has a municipal court. One of those is a joint court. In Glendale and Brown Deer, those two municipalities have banded together to have a joint court with one judge. A somewhat stunning fact is that in Wisconsin, municipal judges do not have to be attorneys. So you have these 240 courts, and about half of them have judges who are not attorneys. All of the sitting judges in Milwaukee County are attorneys, in fact, but the city of Milwaukee will often bring in substitute judges who are not attorneys. I mention this to you just so you're aware of the fact. The state court's office does a great job of educating judges throughout the state, and the non-attorney judges are exposed to some really good education classes. But I just want you to be aware that you may be appearing in front of a judge who is not an attorney. All right, what types of cases do the municipal courts hear? Well, they have exclusive jurisdiction over actions alleging that a municipal ordinance has been violated and where the penalty is a forfeiture. So in the statutes where the legislature says, well, this is a bad thing to do, and if you're convicted of doing it, you'll be ordered to pay a fine. That's a criminal provision. If the legislature prescribes a forfeiture as a penalty, that is a civil offense and one that can be heard in municipal court. I want to just mention, for your information, some categories of the substance of cases which are heard in municipal court, some of which might have a bearing on the cases that you'll be handling on behalf of clients through this project. The first is that probably every municipality that has a municipal court has adopted the state traffic code in its entirety, so that all of the traffic provisions which are enforced by all types of law enforcement around the state, state patrol, sheriffs, are also enforced by local police departments because their municipality has adopted the traffic code lock, stock, and barrel. That does not include criminal traffic cases, for example, second offense drunk driving, but the whole gamut of traffic cases can be heard in the municipal courts. A second category, and this is another one of these, to me, shocking things. So the judges don't have to be attorneys. And this piece is a little bit shocking to me. The legislature has authorized the municipalities that have municipal courts to adopt all of the provisions, all of the violations in chapters 941 to 948 of the Wisconsin statutes. And those of you with experience in the criminal courts know that that's a whole lot of criminal conduct that we're talking about here. So they skipped chapter 940, so you can't, the town of Lannon can't create an offense of first-degree murder, but everything else, starting in chapter 941, can provide the basis for a charge in a municipal court if the local government has adopted an ordinance parroting that language. Then there's a third category of offense, and that's this whole hodgepodge of stuff that municipalities decide to outlaw in their jurisdictions. And there's no end to the types of conduct that they have decided ought to become the basis for a violation. And some of the stuff you've seen, there are various types of loitering offenses, and that list has expanded over time, but loitering for prostitution-related purposes and drug-related purposes. Aggressive panhandling. So you can't prosecute people for just begging, but if it's aggressive panhandling, that is a violation and can be prosecuted in municipal court. Public drinking, a whole range of things that you will not find in the criminal statutes or in the Wisconsin statutes can be outlawed by municipalities. And we may end up seeing some of these types of violations. I don't know if there'll be anything graffiti related to graffiti-related vandalism, for example, that'll show up on some of the citations, but that's a category of violation that the municipal governments are free to adopt or create, and they've done it. I want to make one point about where cases land. The news reports that I've seen indicate that there are a lot of different types of law enforcement bodies that have been active with respect to the protests. So if a violation of these city ordinances, and I'll say just stick with Milwaukee for now, although Shorewood might be involved or other municipalities, Madison. But if a city of Milwaukee police officer cites someone for a municipal ordinance violation, that case will be heard in the municipal court in that jurisdiction. If the municipality is one which has never had a municipal court, and I doubt that we're going to run into that situation, but if they've never had a municipal court, then their cases are heard in the circuit court in which that municipality lies. Then all the citations written by sheriff's deputies, members of the state patrol, those cases are heard in the circuit court. So there may be some citations that are coming through the ACLU as a result of the protests that were written by other law enforcement authorities, and those might be heard then in Milwaukee County Circuit Court. It has not been our intent here to educate you on all the procedures in circuit court, but there are experts among you that I'm sure can be consulted. Municipal court proceedings are civil in nature, important to remember. So they're not criminal courts, although, again, some of the violations really sound like criminal offenses. One big way that plays out is that there's no right against self-incrimination. So no right to Miranda warnings. You can, a defendant facing a municipal charge can be grilled without an attorney around in court. And this will be covered, I believe, in the proceedings on Wednesday noon. But in court, the municipal attorney, the prosecutor, can call the defendant and require the defendant to answer questions on the stand. And an attorney who's ready to jump up and down and say, "This, you can't do that. There's a right against self-incrimination here." That will not be sustained by the judge, or should not be. But it's just good to know that these are civil proceedings and that has some impact on procedures. Municipal courts are not courts of record. That distinction, I don't know how critical it is, but the proceedings in municipal court, the general proceedings day in, day out, are not recorded. Statutorily, the courts are required to record a couple different types of proceedings. Anytime there's sworn testimony, so trials are, of course, recorded. And then over the last couple of years, last few years, we've succeeded, a number of us who work in the municipal courts have succeeded in expanding that to include hearings on motions to reopen or vacate judgments. And also, very importantly, hearings on requests for a poverty determination. And that has been really critical. Our attorneys have not had as complete success as you might hope and expect in persuading judges that our clients are indigent and should not be required to pay the forfeiture, maybe ought to be allowed to do community service. So because it becomes necessary to appeal determinations that are adverse in that area, there is now a requirement that any hearing that's aimed at determining whether a defendant is indigent and therefore ought to receive some other consideration from the judge, those hearings have to be recorded. So that's a general overview of the municipal courts. But you're not done hearing from me, because I want to talk now about the authority of municipal courts. Keep in mind that judges, half of them in the state, are not attorneys. Their powers are somewhat limited, and we've listed here for you the general powers that the judges have that you need to be aware of. First off is the issuance of civil warrants to enforce matters before the court. They're called civil warrants. I'm not sure that distinction means much to somebody who's arrested on one of them. It doesn't mean they're going to be treated more civilly than somebody arrested on a criminal warrant. The impact is the same. They're taken into custody by law enforcement. They can be held, and in some instances can be forced to pay some dollar amount, but they're called civil warrants because these are civil courts. The types of warrants that the judges have authority to issue are, generally speaking, warrants that enforce their judgments. So if there's an unpaid judgment, the judge has the authority to order a warrant to have the defendant picked up, to serve time potentially, or possibly to appear before the court. There are warrants that can be issued to compel appearance by the defendant. Typically, this happens at the initial appearance where a defendant defaults, and the judge is statutorily given the authority, rather than to take a default, to compel appearance by the defendant through the issuance of a warrant. And a third is something that I believe I'm going to talk about a little bit later, possibly, but is a contempt warrant, where a witness is properly subpoenaed and fails to show up in municipal court for a trial. The judge has the authority to issue a warrant to have that witness brought into court and be made to testify, perhaps post a bond, but in any event, that's another type of warrant that municipal judges have the authority to issue. The judge can issue a summons to compel appearance before the court. Again, if there's a failure to appear, and we'll go into more detail on these matters on Wednesday, but generally speaking, good to know that the judge has the authority, rather than issuing a warrant, can issue a summons. A more civil thing, perhaps, for the judge to do. The judge can issue subpoenas, and for all of you practitioners on this training today, it's important to know that subpoenas have to be issued by the municipal judge. And it's a little odd, because in circuit court, you're used to preparing your own subpoena and having it served. The judge doesn't play any role in that. But statutorily in municipal court, the judge must sign off on the subpoena. So it's an extra step that must be taken. Perhaps it won't be necessary for you to subpoena a witness. Maybe you'll have voluntary appearances by witnesses. And there are fees that have to be paid. And again, I'll talk a little bit more about the fees and so on Wednesday. But keep that in mind, the important distinction between municipal court subpoenas and circuit court subpoenas. The judges have the authority to decide constitutional issues. The Supreme Court has made it clear that municipal judges, although they're at the bottom of the justice system pyramid, they do have the authority to determine the constitutionality of ordinances. I don't know that any of the charges that you'll handle for defendants will involve an ordinance that needs to be challenged on a constitutional basis, but the judge does have the authority to decide that. The judge also has the authority to apply the Constitution to the conduct of law enforcement. So if there is a Fourth Amendment issue, if there's a First Amendment issue, the judges in municipal court have the authority to hear those challenges and to decide them. This wasn't always so clear, but the courts have made it clear that those powers exist on the part of municipal judges. Of little importance to all of you here today, the judges in municipal court can issue inspection warrants that command a building owner to allow a municipal employee in to inspect the premises that is perhaps thought to be in violation of codes. I don't think it'll play a role in any of the work that all of us will be doing here, but good that you know it. The judges can order restitution. So there's a separate section of the statute that covers restitution orders by the municipal judges. And good to know, because there may be charges that have resulted from damage caused by protesters or alleged to have been caused by protesters. And it may be that the prosecutors will seek to have restitution ordered as a condition of the judgment. So good to know that it's possible. There's a whole section that defines the restitution powers. And good to know also that the limit is $10,000. It's a small claims limit. So it's a potentially fearsome judgment amount that someone can face in municipal court, but the procedures must be followed, and hopefully we won't get to that point. Hopefully there'll be a not guilty finding and restitution won't become an issue. Finally, at this point, the judges have the authority to punish contempts of court. There are two types of contempt statutorily defined. One is acting out in court. So if you're thinking of putting on a good show for the judge and you get carried away, you do have the possibility of being cited for contempt. There's a definition of what contemptuous conduct is in that respect, and you do have to interfere with the administration of justice and so on, but it is possible. And those types of contempts can result in a 7-day jail sentence, which the judge has the authority to order then and there. And in addition, a forfeiture of up to $200. The second type of contempt is where a properly subpoenaed witness fails to appear for trial. Again, I want to talk more about subpoenas at another time, but the judge does have the ability to issue a warrant to compel that non-appearing witness. If the appearance, and I don't know how you know this till you have the person in court, but if the appearance isn't for a good failure to appear isn't for a good reason, the judge can issue a warrant to have the person brought into court. A power that you don't hear me talking about is the power to provide equitable relief. The legislature, in defining the powers and authority of municipal judges, did not think it appropriate to give them the power to provide equitable relief. So just so you know that you can't ask for it. I want to cover a couple of sort of general areas now, additional things to know about municipal court that you need to be aware of as you defend people. First is with respect to interpreters. Despite various efforts that have been made to improve the procedures in municipal court over time, one area that hasn't been addressed, and I don't know that it will successfully be addressed in the future, but is to be sure there's a broad right to interpreters in those courts. Statutorily, there are only two areas in which interpreters must be provided. First of all, if somebody is suffering from a disability. And that's more ADA required than Wisconsin statutorily required. So that's one area if the defendant is suffering from a disability or possibly a witness. The second is where the defendant or parent or witness in a juvenile case cannot understand or speak the English language. Now, I said juvenile case. So when you take these two statutorily required areas and you look at what else is in municipal court, well, just about everything else is in municipal court, every other kind of case or situation. So the vast majority of defendants who appear in court are not protected by any statutory right to interpreters. What the judges typically do is if someone has a language problem, they will see if that person brought somebody to court who can interpret for the judge, or they'll ask somebody in the courtroom to come up if they have the ability and confidence to come up and serve as interpreter. And of course, you can understand how hit and miss that kind of interpreting can be. The judges also are trained and have access to telephonic interpreter services. So they have the ability to access an interpreter on the telephone, and they're all supposed to have speakerphones in the courtroom that can help them do that. But I want you to be aware that if your client is not English speaking, that you may have to be pushing and pulling in front of that judge to have proper interpreter services provided for your client. Another area are diversion programs. Now, I'm not referring here to post-judgment opportunities for defendants to get a workaround the forfeiture that the judge has ordered. Rather, I'm talking about pre-judgment or pre-trial diversion programs. There is no statutory provision that covers this in municipal court. So unlike the criminal law where expungements are statutorily provided for and have requirements and restrictions, in municipal court, there's no definition of what is a diversion program or who's eligible for it, which some might argue is not so good, but I would argue it's great because you are free, typically at the pretrial stage, you are free to make the case for some type of diversion program that will fit your client and the circumstances of the offense. Some of the types of programs that the court has sanctioned in the past are for first-time shoplifters, and there have been programs for graffiti, people convicted of graffiti, vandalism, and they've been assigned to work for one of the city-funded neighborhood improvement programs that goes out and removes graffiti, so they have to go out and help the city remove graffiti, and it's a form of diversion that can be used to get a case dismissed so that there's no judgment of conviction. So just be aware that that is a possibility. It's negotiated typically at the pretrial with the city attorney. And it's a pretty blank canvas. Next, guardians ad litem. I'd love to go into the history of this in municipal court, but it's not today's topic. Statutorily, the court has a duty to appoint a guardian ad litem if the court has reason to believe the defendant lacks substantial mental capacity to understand the proceedings or assist in the defense. So it's a test similar to what's used in circuit court, maybe word for word. So if you have a client where there are such concerns, the judge has a duty to appoint someone to help the court come to a determination about whether the person indeed meets the standard I just read. And that can be either an attorney or a social worker meeting certain requirements. That rarely happens, rarely. What typically happens is whoever might make the judge aware of this problem, maybe just the defendant through his or her appearance puts the judge on notice. Maybe at a pretrial, the city attorney picks up on something. But what typically happens is there's an informal determination made by the court that this person meets the standard and this prosecution should not continue. It's not a scientific one. It's not a mental health guided decision. but it's a very practical way of disposing of those cases and results in the benefit to the defendant that the case is dismissed. I'm going to leave it at that for guardians ad litem, but there is a statutory provision. And in terms of materials, and I saw a question that I'll try to address a little bit here in a moment, but in terms of the source materials that you'll want to have available, well, the two main chapters of the Wisconsin statutes are Chapter 755, which covers the creation and operation of the courts, and then Chapter 800, which covers the procedures in municipal court. So those two chapters of the state statutes are the prime ones you'll need possibly to consult. We've also made available to you in the materials two other documents that will be of some help to you. One is the Municipal Judge Bench Book. So like the circuit courts, the municipal judges have created a bench book, which is updated annually. And that bench book is nicely divided into chapters which can guide you to information that might be helpful as you represent someone. That's, of course, if these training sessions have any leave any spots that we haven't covered, but we're hopeful that we've told you enough that you may not have to consult the bench book, but it's there. It's a good resource for you to take a look at. The other thing I wanted to mention, the other document we provided is the Municipal Court Directory. So that's a directory of judges in the state with contact information, the address of their court, the names of their clerks, the phone number of the court. That's all contained in the Municipal Court Directory. That's, again, part of the materials that you have access to now. The access to the courts is quite important now because of COVID-19 related restrictions. Some courts have started to do business sort of as usual. We learned the other day that a legal action attorney appeared out in Lake Country Municipal Court in Oconomowoc because the judge there has I don't want to say required, because people may have concerns and not have to show up, but in any event, that judge is conducting business somewhat as usual. Here in our county, that's not necessarily the case. In Milwaukee Municipal Court, there's no walking into the courtrooms right now. And for you to find out exactly how the courts are operating based upon, again, pandemic limitations, you'll want to call the clerk and get some understanding about how you're going to appear on a given case. I filed a not guilty plea on a couple cases in Oak Creek and just got a notice from the court laying out a whole nicely laid out procedure for how they're addressing cases, again, without people appearing in court. So I think most of the courts are trying to take pains so that people know how to protect themselves legally and from a health perspective, but use those phone numbers to contact the clerks. Here in Milwaukee, where I imagine the greatest number of our local citations will go, there's on their website, you can just Google Milwaukee Municipal Court, but on their website, there's an instruction to call a 286 number, and then you get hooked up with a clerk who will ultimately arrange for you to, if you're at that stage, to have a Zoom appearance before the judge, or will assist you in connecting with the city attorney if the case is at the pretrial stage. So that's a very vague response to a question about pandemic concerns, but courts are, like a lot of places, are feeling their way through this, are starting to open up a little bit, but they're not open, not to the extent circuit court is reportedly opening up now, at least on the criminal cases. So I think I'm going to leave it at that for now. And Emma and I are both anxious to answer any questions you might have. I speak for you, Emma, right?
Yeah, absolutely. And I'm just going to flag just a couple more things, but I think
Yep.
there was one more question about I think your comments, especially with, the raising of constitutional issues in municipal court versus, cases that, we might handle in federal court, which I'm going to flag a couple issues there. But, so it's really important to raise all the constitutional defenses to these tickets in municipal court as well.
Yep,
Would you say that's
absolutely.
accurate? Mm-hmm.
Yep, absolutely. The bench book that I made reference to has a whole chapter on determining constitutionality. So the judges have all been trained on it, and they have access to materials. So they shouldn't look blankly at you when you start raising constitutional issues. First Amendment issues probably haven't been raised very much in the past. Fourth Amendment issues are a fairly routine matter in municipal court. Search and seizure issues, probable cause, reasonable suspicion. So those issues are fairly typically raised, or the judge sua sponte needs to take a look at them there. But First Amendment might be a little more, require a little more definition for the court, but definitely raise them.
Great, great. And that's something we're willing to help with as well. So, if you're not as familiar with the constitutional kind of arguments surrounding these citations, please feel free to reach out, and we're happy to, help you with those legal research questions. If possible and time permitting, we're happy to, provide a memo if we have one on some of these issues.
And I should mention on Friday's training, we'll talk about appeals. So the municipal court, of course, isn't the last say, but there is a clear right to take an appeal to the Milwaukee, or the circuit court of the county in which the muni court lies.
And just to kind of round things out, I'm not going to spend a ton of time on this at all. There are just some issues to raise in the cases that, we take as federal cases, that you might want to consider and explain. And I put, little asterisks by the last two, because that's something, you also might come across. Like we've already discussed the Fifth Amendment rights, that there's no right against self-incrimination as well. And so, you really want to think about that, again, given the gamut of your client's tickets, even if you're not representing them and have a limited scope representation. If they have a criminal ticket, a criminal citation, and you need to think about, and they want to file, perhaps a federal case or something like that. While you wouldn't, of course, be responsible for that, you do want to inform them that what they do, in municipal court, what they do with their other cases can inform that. Release dismissal agreements, that's also, that definitely can happen where in one case, the deal will include not suing and making a civil rights claim. So again, all of these things are things you can consider. Exhaustion is often an issue, so you can't bring a 1983 action that would impugn the validity of your conviction or sentence, again, depending on what the severity of the ticket is, and if they have other tickets as well. And res judicata and abstention doctrine are all things that we often have to think about and deal with in our federal cases. So it's more just a flag to think about if your client is discussing and wanting to bring a constitutional claim, especially in federal court. So are there any other questions? We're happy to take questions in this last few minutes. And again, I want to just kind of flag for you coming up what the next session will be, which is going to talk about a lot of these things more in depth, really going through pretrial matters and trial practice. I believe, the appeal deadline will be starting at part 3. And so you'll talk about kind of everything above that: trial and judgment, pretrial conference, discovery, substitution, initial appearance, and alleged violation. In part 2 on Wednesday, and then in part 3, appeal deadline, due date, and sanctions for non-payment. And again, we're going to have materials in those folders. There's a lot more templates available for filing these motions and requests that come in here. And so there's a lot to look forward to. And I hope you are all able to join us then. I'm just going to take a look at this chat to see if there's anything else It looks like as well that Madison also has a lot of these COVID precautions. Everything is looking like it's by phone. And I know in some other courts, you know, depending on, you know, what their capability and resources are, a lot of the dates have just continuously gotten pushed out. So I think every court, like Judge Gramling mentioned, it, you know, can be very different. So we encourage a call to the court to just ask what their procedures are and what their timelines are looking like. Although I will say in Madison, I've seen some, I'm not sure of the updated information, but I've seen court dates coming up and as soon as the first week of August. So, you know, all things if you're in Madison representing individuals, you know, I think there's a different timeline between Milwaukee and Madison. I'm not seeing any other questions, but we look forward to having you on again on Wednesday and Friday. And if any other questions come up, please feel free to contact me. I'll put my email here in the chat. It's also on the email that went around. If you have any questions or comments or, you know, information that you'd like to see, please feel free to let me know. And I'll do my best to put it in there. Otherwise, we look forward to seeing you then.